Yes, so this one is DB C-9 12-4-8, so that everybody can find that one. It was sent out this afternoon to everyone. It was as quick as it was ready, all translated and in correct final form. So on this one, I move that Bill C-9 be amended in Clause 12A on page 4 by replacing lines 8 and 9 with the following: for the purposes of this division, and then B on page 5 by replacing line 19 with the following: counsel and one person from the roster of laypersons have reasonable grounds to believe that the pub, and then C on page 10 by replacing lines 27 and 28 with the following: C, a person named in the roster of laypersons. D on page 15 by replacing lines 13 and 14 with the following: A, 2 members of the council. B, a judge named in the roster of judges. C, a person named in the roster of laypersons. And D, a lawyer of at least 10 years standing at the bar of any province. So, for this one, this amendment was really suggested by Professor Richard Devlin in his excellent recent testimony before our committee. Professor Devlin is a professor of law at Dalhousie University. As he stated in his brief that he provided to us dated April 24th, quote, I am here as a member of the board and of the Canadian Association of Legal Ethics, and because in the last several years I have co-edited 2 books which directly address the challenges and complexities of designing an appropriate complaints discipline regime for judges. The books are regulating judges and disciplining judges, and they bring together scholars from around the world to give their best wisdom on the topic. So a major part of his brief dealt really with the need to have greater layperson participation in this judicial disciplinary process. And as he stated, quote, there is insufficient lay representation in the process, thereby compromising the principles of impartiality, independence, and representation. There is only representation at 2 stages of the process. They are one of the 3 members of the review panel and one of 5 members of the full hearing panel. This is ad hoc and occasional. Lay representation should be pervasive and structural. And so included in his proposals were that A, there should be lay representation on the reduced hearing panel. He suggested that that part be revised to say a person named in the roster of laypersons. B, that there should be lay representation on the appeal panel, that he suggested that that provision be replaced by A, 2 members of the council, B, 1 judge named in the roster of judges, C, 1 person named in the roster of laypersons, and D, a lawyer of at least 10 years standing at the bar of any province. And he also suggested there should be lay representation in the decision whether to go forward with an anonymous complaint, and he suggests that part should be rewritten to say if only 2 members of the council and 1 layperson from the roster of laypersons have reasonable grounds. So, as I stated at this committee last week, I said, we've also heard repeatedly about the importance of a layperson at each stage of the process. Professor Richard Devlin stressed that, in the Ontario Justice Council acknowledged the critical importance of that in their process. Professor Devlin stated that the values of impartiality, independence, and representation are compromised without sufficient lay representation. And then I asked Ms. Warner of the Ontario Judicial Council about this at our committee recently. And in our exchange, I said, I'm wondering if you have a brief additional comment about the lay people you have on your panels in Ontario as well, because they deal with, of course, provincially appointed judges in Ontario. It sounded like you have them throughout the different processes. Is that correct? And she answered, Ms. Warner answered, that's correct. Yes, at each stage, including to be able to summarily dismiss a complaint, a community member has to agree with that disposition, and a lay member is involved throughout the process. I said, okay, thank you very much. And she then went on to say, I have to tell you that it's quite an invaluable perspective in the deliberation process, and also having the lawyer member is quite helpful because they can report on what they're seeing in courts elsewhere and give a perspective on whether the conduct is troubling to the profession. So both perspectives are helpful in the deliberative process. And I said, absolutely, and I can say as a lawyer myself, certainly we don't always have the same perspective as the public, so that provides a valuable difference as well. And when I asked when we had the Canadian Judicial Council representative in front of us recently, she said in response to that issue, she said, "I would not think it's necessary at every stage because you don't see it anywhere else within an administrative tribunal, not at the screening stages and not at others." And I responded, "They do have them," referring to Ontario Judicial Council, "at their other levels, which is much more akin to what the process is rather than just comparing it to different administrative tribunals." So, yeah, in that respect, certainly comparing a judicial council to an administrative tribunal, of course, judges hear very important cases dealing with the public. It's very important that the public feel like they are represented in these processes, that they have complete trust in these processes, and I think that's an important reason to involve lay people in the process at every stage, as has been suggested to us by substantial witnesses. And one more thing that I want to add on this laypersons issue is that the shall-may issue that Senator Clement previously raised about Section 82, it's actually corrected with my amendment, just happily. So that issue doesn't exist anymore in that particular provision. So I would ask for your support. Thank you. First of all, I just want to comment, I mean, I'm a lawyer myself, but I certainly recognize that lay people have a very valuable role to play in these types of processes, and that lawyers don't know everything, and we sure shouldn't think we know everything, and especially in processes like this, which the public is so impacted by, right? I mean, judges are the ones who are deciding all kinds of cases, criminal cases, family law cases, corporate cases, all of these types of things, and to think that, oh, only the lawyers or only judges can have smart viewpoints on a process, I don't think is the right way to go, especially on issues like this, disciplinary procedures. We've seen many very visible cases over the years that have generated considerable news coverage, where perhaps it would have been a valuable thing to include lay people on the different parts, and obviously the department thought that it was valuable, and that was the product of consensus because they've included them on two parts of the process, just not on the other ones. And given the considerable evidence that we received from Professor Devlin, who was an excellent witness here, and has obviously considered this subject with much deliberation over the years, even writing books about it. These are the types of things that even law professors think should happen. So I also think it's important on this issue to remember when we're considering this Bill C-9 today that this is the third time that the federal government has introduced and tried to proceed with this bill in the last few years. And consultations, when we hear about that, consultations by the federal government on this bill with the provinces, with the other provincial governments, were done dating as far back as 2016, and with many, of course, provincial governments that have changed during that time. And I would guess that a lot of the, and certainly this bill is, for the most part, there are many good parts of this bill. I'm simply trying to make it a bit better, which is always what our goal should be. So there are also the consultations that took place with judges as well, I imagine, again, because this has been a work in progress for quite a few years, may have also evolved since the time that the consultations were initially done. And we also saw through the evidence that we received that the public consultation actually seemed to be actually very minimal, like only 74 responses to an online survey out of the millions of people that live in Canada. So really, this Judges Act has not been, the disciplinary process has not been revised for decades. And so I think if we're going to, when we're going to do it, as a large bill like this does, we should do it right. First of all, dealing with the Court of Appeal level, actually, as Senator Dalphond indicated before, yes, one of my later amendments is to, as the Canadian Bar Association president came and testified, is to allow that Federal Court of Appeal to actually have a role in this process, because it's otherwise the only court, the only actual court, as Bill C-9 currently exists, that would hear one of these cases would be the Supreme Court of Canada if they decided to grant leave. And as we've heard, that's a very rare case, and of course Supreme Court of Canada has to consider whether something is in the national interest, not just simply whether they think a decision was made incorrectly, but whether something is in the national interest in order for them to be able to hear such a thing. So that's why I am on you know, with the very substantial weight of the Canadian Bar Association president and that large lawyers organization, and the Advocate Society as well. That's why one of my later amendments, so I guess you can consider that if you're uncomfortable about the fact that there may be a layperson on what could be potentially something dealing with law. Again, I mean, if it were important to only have lawyers and judges dealing with these types of matters, we would only have lawyers and judges on this committee. I think that people who are not lawyers and judges provide a very valuable perspective to this committee, and I don't think that there's any difference here as well, given what Senator Dalphond said about that, of course, the people constituting the particular judicial council and the panels for these matters would be making sure that those appointed from the rosters were appropriate people to have on there. They would also be ensuring that the lay people that they had in their roster would be appropriate people that would receive necessary training and provide that perspective. You know, that is something actually even about the reduced hearing panel. Professor Devlin talked about that having the reduced hearing panel only have judges on it. He said right off that it would compromise the principles of impartiality, independence, representativeness, and transparency. And he also raised the concern that there's a clause of the Act, Clause 115, suggests that reduced hearing panels might not be public. So he said that then, as a consequence, a judge could potentially choose to avoid any lay engagement at that stage of the process and have it in private. So my amendment actually directly corresponds to exactly what Professor Devlin suggested, and that was the exact change that he suggested on that particular one, was to, as I was explaining when I set out the parts of his brief and how he testified about it today, talking about the appeal panel. Yeah, he suggested that on that one it should be replaced by 2 members of the council, 1 judge named in the roster of judges, and 1 person named in the roster of laypersons, a lawyer of at least 10 years standing at the bar of any province. So yeah, that was, and so when your first question asking me whether I considered having each of those processes you know, dealt with in a separate amendment, no, I didn't actually consider that. As I stated when I was explaining my amendment initially, I was modeling it after the very helpful testimony that Professor Devlin gave us. He provided each of those different components. The only part of his proposal that I didn't include was the part about the request by a complainant for reconsideration of a decision to screen out a complaint, that they have lay representation on that, because that wasn't going forward as an amendment. So I wanted to make it as easy to understand as possible, and rather than have multiple amendments that would deal with this, I thought that it was basically something that is comprehensive and possible to do all in one amendment rather than dividing it up and making it more complicated. As you know, this was something that he prepared, put considerable thought into it. As you may remember, when he testified, we were all many of us were quite impressed with his testimony and asked him to please work on some amendments that very night, because we might potentially be going to clause by clause the next day. And he worked on things and provided us with this information, and my amendment is very much inspired by what his considerable years of work on this issue and the proposals that he gave to us, and that's why I based it on that.
Thank you, Senator.